Mr. Grady. I'm gonna put him in it.
We are on.
Okay.
All right. Thank you, ma'am. All right. Do that. Oh. See. You doing camera 2 or not? Just a 3. Let's see. We'll still do camera 3. All right. DDC. Good morning, DDC. Good morning, DDC. I know we're not muted. Can somebody call DDC? Thank you, ma'am. I appreciate it. Again, I apologize, even though my apology don't mean anything, do ya? Because I upset your routine. But I'm glad I can make you laugh. Good morning, DDC. Do you have a copy of the list?
Yes, sir.
All right, can you bring me Mr. Jones, number 7, Robert Jones first, and then number 4, Mr. Zarka? They have retained counsel. Okay, gentlemen, DDC, what's your name, sir? Mr. Robert Jones, sir, this is Magistrate Charte. Is it Robert Mitchell Jones?
Yes, ma'am.
Sir,
Yes.
case number is 16045-84701. You have an attorney. Go ahead, counsel.
Lisa Cole appearing on behalf of the people.
Good morning, Your Honor. Good morning to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Jones. We waive any formal reading of the warrant and complaint. Stand Mr. Jones mute. Respectfully ask the court to enter a not guilty plea. Thank you.
Thank you. I'm gonna enter plea of not guilty. Court date is November 26, 2024, 36th District Court, pretrial in front of Judge Austin Garrett. Mr. Jones, bond conditions, you're not to possess any firearms, any other dangerous weapons, not to have contact with the Tracy Hooks. And that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Understand that, sir?
Yes.
Thank you. All right, Counsel Coyle, go ahead, Esteban.
Yes, Your Honor. No objection to a $5,000 personal bond in this matter. No contact with the MGM casino. He did turn himself in. This is a case from 2016, Your Honor. It has no habeas history on it.
Okay. All right, let's put MGM Casino. So while this case is pending, even though it is from 2016, no contact with MGM Casino. Understand that, Mr. Jones?
Yes.
Okay. And Council Perkins, did you want to add anything else or any objection to the personal bond?
No, Your
Bond
Honor,
conditions?
nothing further.
Okay. Thank you. Bond in this case is going to be $5,000 personal bond. Sir, that means nobody has to pay any money for you to get out of jail. Just go to court and take care of this matter. Understand that, Mr. Jones?
Yes, ma'am.
Thank you. You can step aside, sir.
Thank you, Your Honor.
Yes, sir.
Joseph Zarka.
Mr. Zarka, this magistrate Chatfaser. Good morning, sir.
Good morning, Your Honor. How are
Is
you
it
today?
Joseph D. Zarka, sir?
Yes, Your Honor.
Okay, your case number is 24060274001. You have an attorney. Go ahead, Counsel Blake.
Good morning, Your Honor. Wright Blake appearing on behalf of Joseph Zarka. Judge, we waive a formal reading of the felony complaint and ask the court to enter plea of not guilty.
Enter plea of not guilty. Court dates are November 21st. Again, let me repeat it. November 21st, 2024, probable cause conference, followed by preliminary examination, November 27, 2024. Both matters are in front of Judge Jefferson. Okay, Mr. Zarka, couple bond conditions, no drinking of any alcoholic beverages and no driving without a valid driver's license. You understand that, sir?
Yes, I understand, Your Honor.
That being said, this is 2022. Counsel Vincent, go ahead, Esteban, please.
Thank you, Magistrate. Good morning. Steve Benson, P71917. Initially, in candor, I was going to ask for a cash bond, but seeing as though the defendant has retained very good counsel in this matter, I'm not going to be objecting to a personal. I understand that the incident date was 11/5/22, but I hope, your Magistrate, you can appreciate this. We're going to be out asking for an alcohol tether. This is the third offense, OWI. He's looking at 1 to 5, but I think that could be enhanced too because of the fourth offense notice. I have on this that his license was revoked at the time of this incident. I still believe that he does not have a license through the present. And just based on the allegations that the defendant was found on one of our freeways where his car was idling, it was disabled in the right lane. That he was intoxicated. I think he blew a .13. So for all of that, we're going to be asking for an alcohol tether. We do feel as though this defendant poses a danger to the community, whether or not there's a restriction for no driving. He's been told not to drive in the past, and he continues to drive. I'm not going to get into the flight risk. I know that he was previously in Georgia. I have some history there regarding a conviction in Georgia. But with all of that being said, all we're going to be asking for is an alcohol tether. Again, he's retained really good counsel, so I'm not worried about him not appearing or being a danger to a certain extent, but he is a danger because this is a third offense notice.
Thank you. Counsel Blake, go ahead, sir.
Your Honor, I'd like to thank Brother Counsel for the compliments. This case was a 2022 case, which since then, Mr. Zarka he's been on probation to Judge Knapp in Third Circuit. He's also has a pending case in Monroe, which are not alcohol related. We're scheduled there tomorrow. And we're just in the process of wrapping everything up when this not in custody warrant, which has never come up in the past 2 years, popped up. I looked it up. I had Mr. Zarka turn himself in order to deal with this before we go back to Monroe, but it's never popped up. The warrant was just issued. So I don't know the mystery behind that, but he's up under all types of bond conditions and he can drink. He can't violate any state law of Michigan. To put a tether on him would serve absolutely no purpose except to have him pay more money, which he doesn't have. He paid money for bonds. He's being tested. He has strict compliance with his bond. So we would ask the court to release him on his own recognizance and not to impose the alcohol tether. Thank you.
Thank you. Council Vincent, can you tell me, do you have any information that he's been involved with alcohol since 2022?
I don't. The only other information that I would give to this court, and I'm sure Mr. Blake knows this as well, at the time of this incident, he was on probation already. So while he was on probation for a domestic violence second, allegedly he ends up committing this offense. But to answer your question, I didn't see anything alcohol related since the time of this incident through the present.
Thank you, sir. I've heard the representations of both sides. This particular matter, bond's gonna be $15,000, personal bond. Okay, this court doesn't feel at this point in time, there's enough information to put him on an alcohol tether. So no tether, $15,000 personal bond. Mr. Zarka, you can step aside. Thank you.
Thank you, Your
DBC,
Honor. Have a
stand
great
by.
day.
Thank you.
MEP Wayne County. Mr. Williams. Mr. Williams,
Yes, ma'am.
you hear me, sir?
Yes, ma'am.
Okay, please say your full name.
Reginald Dante Williamson.
Sir, I'm Magistrate Chattea, case number 24058-00001. Sir, you have an attorney?
Yes, ma'am.
Good morning, Your Honor. Jessica Shive, P number 81798, on behalf of Mr. Williamson, who is from a reading, understands his constitutional rights and stands in you.
Thank you. I'm gonna enter a plea of not guilty. Court dates are November 25th, 2024, probable cause conference, followed by preliminary examination, December 2nd, 2024. Both matters are in front of Judge Sabri. Mr. Williamson, bond conditions. You're not to have contact with the Jessica Harvey. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the person's residence. Do you understand those bond conditions, sir?
Yes, ma'am.
And then I also have, as of September, looks like 25th, 2024, a warrant was issued for Mr. Williams, $5,000 cash surety. This court doesn't have the authority to modify a felony capious bond. My understanding, there is no attorney to represent the prosecutor's office. So, Counsel Shive, go. You have anything new for me?
Your Honor is correct. According to Mr. Williamson, he went to the wrong courthouse. He was still on the tether, still is. He was picked up at home on that tether. I know this court doesn't have authority to change that bond, so we are currently working on a motion as we speak. So I just asked the court to keep the file nearby. And if Wayne County Jail is not able to stay on, I'd ask the court to waive his presence later if we do get an answer to get this changed, Your Honor.
Address it, but right now, his bond's gonna be $5,000 cash surety. And if it changes, you can waive his presence later on when we recall this.
Thank you, Your Honor.
Okay, all right, Mr. Williams, let me say this, sir. Okay, if your bond changes, so that it changes to maybe a personal bond or something else, your attorney will do another hearing without your presence, okay? And then Wayne County will get the paperwork. Do you understand that, sir?
Yes.
Okay, and so today is Thursday, the 14th, so that means bond redetermination will be Monday, which will be November 18th, 2024, 9 o'clock in front of Judge McConaughey or Judge Williams, who will look at the bond amount and bond conditions. Mr. Williams. Counsel Shive, is that it?
Yes, Your Honor. And then I can go in a breakout room with the juvenile, Mr. Grady, if they're still on.
Okay. Let's put, okay, Counsel Shive. Close this. That concludes Mr. Williams' arraignment. Thank you, folks. Deputy, was there anything else?
No.
Thank you.
Thank
Take
you.
care.
Thank you.
On to Quan Grady. Please unmute.
That's a joint breakout room.
All right, Mr. Grady, this is Magistrate Chartea. You're gonna go into a digital attorney-client room. Okay, so you have the opportunity to speak to an attorney. Do you understand that, sir?
Yes.
Okay, so. Hold on for a moment. All right, just push button. So you can be. Thank you. Is that, let's see, we got Attorney Polk that came in late. Counsel Polk,
Yes, Judge, I will.
sir, how can I help you?
I'm looking to see if Mr. James Liddell made the list.
Liddell?
Yes.
No, sir. I don't have
Okay.
a Liddell.
All
All
right.
right.
Thank you
Thank
so
you,
much.
sir.
Great day.
You too. All right. DDC, let's continue.
Davion Cordell Stewart.
Hold on. Oh, Mr. Stewart, sir, this magistrate at Chartea, sir. Good morning. You're here on criminal matter, case number 20057599601, sir. You have an attorney. Go ahead, counsel.
Good morning, Your Honor. Janice Stevenson appearing on behalf of Davon Stewart. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Stewart has been advised of his rights, Your Honor.
Thank you. I'm gonna enter a plea of not guilty. Court dates are November 25th, 2024. Probable cause conference followed by preliminary examination, December 2nd, 2024. Both matters are in front of Judge Robbins. Mr. Stewart, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
And is my understanding is, let me see if I don't see a capias, but it's my understanding
It
that,
is.
sir, you failed to appear in court. However, I have here, and this is a capias, felony capias. So the attorneys for the city are not participating. Am I
That's correct.
correct, Counsel Coyle?
That's
Okay.
correct. Thank you.
Thank you. And I see a bond order. Go ahead, Counsel Stevenson. Go ahead as to that.
Your Honor, we have, our motion to reduce bond has been granted in the amount of $20,000 personal with a GPS tether and a curfew from 10 p.m. to 6 a.m. Does the court have that written order?
Yes, ma'am.
Okay, ask the court to follow that order, Your Honor.
Okay, GPS curfew, 10 p.m. to 6 a.m., $20,000 personal bond. Mr. Stewart, that means that nobody has to pay any money for you to get out of jail. However, there will be a curfew. I mean, there will be a GPS tether on you. And I'm putting that down on your paperwork. I believe I took care of that. Counsel Stevenson, anything else?
Nothing further. Thank you, Your Honor.
Thank you. Thank you, Mr. Stewart. You can step aside.
Your Honor, what was those court dates?
Did you hear?
November 25 and 12/2.
Who's next, DDC? All right, here we go.
Terrell Dion.
What's your name, sir? All right,
Terrell Dion Anderson.
Mr. Anderson, this magistrate at charge of the sir. You're here on a criminal matter, case number 240-6050901, sir. You have an attorney?
No. Oh, yes, court appointed.
For the
yes.
record, Your Honor, Janice Stevenson appearing on behalf of Terrell Anderson. Your Honor, Mr. Anderson stands mute, waives the reading of the information. We ask that a plea of not guilty be entered on his behalf. Mr. Anderson has been advised of his rights, Your Honor.
Thank you. I'm gonna enter a plea of not guilty. Court dates are November 25th, 2024, probable cause conference, followed by preliminary examination, December 2nd, 2024. Both matters are in front of Judge Sabri. Mr. Anderson, bond conditions. One, you're not to possess any firearms, any other dangerous weapons. You are not to go back to the 3033 Clemens residence. It appears you and the complainant reside at that same location, bless you. And you're not to have contact with the complainant, Shyla Ailey or Ely. And that means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Counsel Vincent, you're here for the people?
I am. Thanks, Magistrate. Good morning. Steve Benson, P71917. Magistrate, remand's available to us to ask, request, and that's what we will be doing under 6.106, uppercase B, the number 1, lowercase a, lowercase I, uppercase B. This defendant is currently on parole for 2 convictions in 2015, one of which was assault by suffocation and strangulation. The other is carjacking. The assault by suffocation and strangulation, he's serving 3 to 10. The carjacking is 3 to 20. He was paroled on the assault by suffocation 5/23 of 23, and his parole is supposed to last until 5/23 of 25. He was paroled for the carjacking on the same date, but that parole extends to April 6th of 2030. He's being charged currently with this GBH as well as a DV. And I think, Your Honor, because she's so diligent, ended up reading the allegations here. Allegedly, this defendant ended up beating this individual 2 different times in the same instance. And it just so happens this individual is carrying the defendant's baby. She's 12 weeks pregnant. In addition to the alleged assault allegations, we have a witness here who tried to intervene when this defendant was beating the individual that's carrying the defendant's baby, as well as witnessing him threatening to kill her. We find him to be a danger, absolute. Remand's available. That's what we're asking for.
So I just want to make sure he's got 2 prior felony convictions in the last 15 years, correct?
Not just 2 violent felony convictions, including
Right.
Right, correct.
All right, thank you. Counsel Stevenson, go ahead, Esteban, please.
So, Your Honor, we're going to ask the court to set nominal bond in this matter. Mr. Anderson has been working, Your Honor, since he did get his parole in May of 2023. I am not aware of any parole violations, Your Honor. I'm not aware of any detainer from the Michigan Department of Corrections. As far as the information I have, Mr. Anderson has been in compliance with his parole. And actually it's that parole, Your Honor, which we believe decreases the likelihood of Mr. Anderson doing anything like what he was accused of. He knows that if he violates his parole in the manner that's been alleged or any other matter, that he's going to go back to prison. And so we're denying those allegations. We believe that the people's case rests upon the cooperation of this independent witness who's indicated in the investigator's report, which we certainly don't presumed to be totally true, but the investigator's report says that that independence is what is not cooperative and that independent witness is not cooperative and doesn't want to have anything to do with this situation. So I would ask the court to leave this up to the Michigan Department of Corrections as to what they decide to do or not to do. I'm not aware of any violations, not aware of any detainer, and we're asking the court to set nominal bond. And we'd ask for a GPS tether in that Mr. Anderson, with a personal bond, if the court would consider it, Mr. Anderson and the complaining witness will not be living at the same location.
Thank you. Counsel Stevenson, and I just want to make sure, are you saying that he doesn't have 2 prior felony convictions, violent felony convictions? Or no?
I did not say that.
Okay, I just want to make sure as to that. So as to whether or not Rule 6.106B1A, 2 little i's, big B, about during 15 years preceding the commission of a violent felony, the defendant has been convicted of 2 or more violent felonies under the laws of this state or substantially similar laws of the United States or another state arising out of separate incidents, if the court finds proof that the defendant's guilt or evident or the presumption great. So, and what I want to make sure, Counsel Stevenson, are you saying, and I just want to make sure, does this apply or not apply?
Your Honor, our initial request was for nominal bond, and we stand by that request.
Thank you. All right.
You're welcome.
I appreciate it. All right. And let's see. Yes, GBH, which is a 10-year offense. Allegedly, there is injury to the complainant, approximately 12 weeks pregnant. The defendant, whether the defendant is father or not, but in this case, it indicates that the defendant is a father per the complainant. Complainant was taken to the hospital. Court finds that we find that Mr. Anderson, he is a danger. Court also finds that Court Rule 6.106, where he has 2 prior felony convictions within the last 15 years of this case, that it does apply. He's going to be remanded. And whether he's on parole or there's parole detainer doesn't show, and the court doesn't see whether that applies or doesn't apply, whether there is a parole detainer or not. So that concludes the arraignment of Mr. Anderson.
Thank you, Magistrate.
Thank you.
Thank you, Your Honor.
Thank you, ma'am.
Excuse me, Your Honor.
Council Byrd, yes, sir.
The juvenile for some reason disconnected.
Okay. So I thought Council Shive was doing the interview. Are you doing the interview?
I was.
All right. DDC, stand by for a moment. All right, so are you finished with the interview or not?
Nope, I still need to finish the interview.
Okay. No problem. We'll put you guys back in,
Okay, I'll let her know. Thank you.
we'll put you guys back into a digital room, breakout room.
Thank you.
Yes, sir.
Hello, we got disconnected.
I know. I'm gonna put you back into a room.
Thank you.
Okay. Just hit the button. Thank you. All right. DDC, who's next?
Aaron Marcel Fields.
Mr. Fields, Good morning, sir. This magistrate at Chappaqua. Not only do you have a criminal matter, sir, but you also have some misdemeanor matters where you did not show up for court. We're going to recall the warrants. You're getting a personal bond. Nobody has to pay any money for you to get out of jail on these misdemeanor matters. The maximum penalty is up to 93 days jail and or $500 fine. Do you understand everything that I've told you so far, sir?
I just missed the, like, part. I mean,
Let me tell you, you have misdemeanor matters, traffic matters that you did not show up for court. We're recalling the warrants. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail. Hold on again. Counsel Byrd.
The juvenile disconnected again, Your Honor.
All right, stand by. Mr. Fields, stand by. Thank you for your patience. Court apologizes, but we need to do this other individual. Put him in an attorney room. Here we go. Let's try this again. Yep, okay. Mr. Fields. Did I lose you?
yes, ma'am.
Okay, all right, Mr. Fields. The misdemeanors, maximum penalty is up to 93 days jail and or $500 fine. Court's gonna enter plea of not guilty. The tickets are P103-1077, driving under a untitled vehicle, improper plates, no insurance misdemeanor. Next ticket is P129-4502, no insurance misdemeanor, driving while unlicensed. Next ticket is P130-3988, driving while license suspended, no insurance misdemeanor. Last ticket is P1362417, no insurance misdemeanor, drama license not valid or improper license. Court date is December 20th, 2024, pre-trial in front of Judge Williams. Sir, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir?
Yes, ma'am.
Okay, that concludes the traffic matters for this remand. Let's see what I wrote down. Can I have the file on Anderson, since nobody wrote down the order? Bless you, the bond conditions. That's all right. Yeah, thank you, ma'am. Yeah, all right. Mr. Anderson's file. All right, Mr. Fields, please say your full name.
Aaron Marcel Fields.
Thank you, sir. Your criminal matter is 240-5640-701, sir. You have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Aaron Fields. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Fields has been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are November 21st, 2024. Probable cause conference followed by preliminary examination. November 27, 2024. Both matters are in front of Judge Jefferson. Mr. Fields, no illegal controlled substances that you can possess, buy, or sell. Do you understand that bond condition, sir?
Yes, ma'am.
Counsel Coyle, go ahead as the bond, ma'am.
Yes, Your Honor, this is a search warrant. A lot of drugs were recovered, guns and money. I do know it's not assaultive. He has no capious history on this matter, no criminal history that I am aware of, Your Honor. Based on that, the people request a $50,000 personal bond.
Okay. Also with that, Mr. Fields, no weapons of any kind, no firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
Okay. And Counsel Coyle, what was your recommendation?
50,000 personal.
Counsel Stevenson, any objection?
None at all. Thank you, Your Honor. Thank
Thank you. Bond in this case is $50,000 personal bond. Nobody has to pay any money for you to get out. You may be looking at a monetary bond. Please take care of your matter. Good luck, sir. You can step aside. What's your name, sir?
Devontae Monta Robinson, ma'am.
You're here on a criminal matter. Case number is 230-576-4801.
appearing on behalf of Devontae Robinson. He stands mute, waives the reading of the. Mr. Robinson has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of court date is November 25th, 2024. It is a review court date in front of Judge Robinson. While this case is pending, you're not possessing any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
I would also indicate on March 15, 2024, a warrant was issued for Mr. Robinson, probation violation, $1,691, cash or surety was the amount. Counsel Coyle. Go
Yes,
ahead,
Your
ma'am.
Honor, this Lisa Coyle appearing on behalf of the people. This is an adjudicated matter. He did plead guilty to a misdemeanor. I have no objection to that cash surety being converted to a personal in this matter.
Counsel Stevenson.
So move, Your Honor.
Okay. Well, the question is Judge Robinson hasn't given the court authority. So is there any new information? Anybody approach Judge Robinson?
We have a motion that's been submitted and I just checked and we have not yet received a response, Your Honor.
Okay. All right, Mr. Robinson, I'm gonna have you step aside because we're gonna see, well, you know what? Bond is gonna be $1,691 cash surety. The court doesn't have the authority to modify Judge Robinson, yes, misdemeanor bond. However, it's in the works to see if your bond is gonna change. Do you understand that?
Yes, ma'am.
So just understand, if it does change, your attorney, Counsel Stevenson, will probably waive your presence. Is that correct, counsel?
If it pleases the court, yes.
Okay, so right now the bond is gonna be $1,691. I'll hold the file to the end of the session to see whether or not it's gonna change.
Okay.
Thank you.
Thank you. Thank you, Mr. Robinson. You can step aside.
Thank you, ma'am.
Yeah. You want to sit?
What's your name, sir?
Terrence Howard.
Mr. Howard, this magistrate at Chanticleer. You're here on a criminal matter, case number 240-455-6701. Sir, you have an attorney?
Janice Stevenson appearing on behalf of Terrence Howard, who stands mute, waives the reading of the information. After the plea of not guilty entered on his behalf, Your Honor, Mr. Howard has been advised of his rights.
Thank you. I'm going to enter a plea of not guilty. Court date is November 27, 2024, pre-trial in front of Judge Austin Garrett. Mr. Howard, bond conditions. 1, you're not to possess any firearms or any other dangerous weapons, and you're not to have any contact with Adrena Smiles. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Understand that, sir?
Yes.
All right. Counsel Vincent, go ahead, Esteban, please. This is from
Thank-
a year ago.
Yeah, I see the same thing, actually, a year and a month ago, exactly. You know what, there was an assault that allegedly occurred apparently at some repass, but there were no injuries that were noted to the complainant. Magistrate, you're right, over a year. I don't have an assaultive criminal history, no objection to personal at this time.
That being said, Counsel Stevenson, no objection to a personal bond. Is that correct, ma'am?
None at all, Your Honor, but this one's also gonna get scheduled on Judge Garrett's docket?
Pardon me, ma'am? Yeah, this is going to Austin Garrett, and yes, and it is November 27th. That's what I'm
Okay,
being
yeah.
told.
All right, no objection to the personal bond, Your Honor.
In this case, it's gonna be $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Understand that, Mr. Howard?
Yes, thank you.
Good luck, sir. You can step aside. Sir, what's your name?
Jamal Jerry Spears Parker.
I'm sorry, say it again.
Jamal Jerry Spears Parker.
Mr. Spears Parker. Sir, this magistrate at Chanticleer here in a criminal matter, case numbers 240-605-1301. Sir, you have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Jamal Spears Parker. He stands mute, waives the reading of the information. After the plea of not guilty be entered on his behalf, Mr. Spears Parker has been advised of his, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are November 26, 2024, probable cause conference, followed by preliminary examination, December 3rd, 2024. Both matters are in front of Judge Taylor. Mr. Spears Parker, some bond conditions. 1, you're not to possess any firearms or any other dangerous weapons. 2, you are not to have contact with Laura Clavon. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Let's see what else. Also, you're not to go to the Mount Elliott residence while this case is pending. It appears that Ms. Clavon, the complaint, resides at that location. Do you understand that bond condition and the other bond condition, sir?
Yes, Judge.
All right, Counsel Coyle, go ahead, Esteban, please.
Your Honor, in this matter, the people requesting a 25,000 cash surety, tether house arrest to some other location. This appears to be his cousin, and they got in an argument. He then assaulted her and punched her in the face, took her wallet, punched her again up to 6 times, allegedly. Then he attempted to use her Cash App card on the same day. He does admit that he tried to use the card. He does admit his claim is that he was given those items by the complainant in this matter. But I believe that the fact that she has a broken, a fractured eye socket or cheekbone and a broken nose would show, and then she went to Beaumont Hospital in Troy for treatment that would beg to differ with his version of events. Your Honor, it shows that he's, I do not see a criminal history for Mr. Spears Parker. I note that he's 26 years old, but extremely assaultive, a danger to the complainant in this matter. So I'm asking for 25,000 cash surety, tether house arrest. Thank you.
Thank you. Counsel Stevenson, go ahead, ma'am.
Your Honor, we would ask for a personal bond, no objection to a GPS tether. We thank the people for noting the absence of criminal history, the absence of KPS history for Mr. Spears Parker, who's 26 years old. He's employed, Your Honor, with one of the local car manufacturers, works 7 in the morning until 3:30 in the afternoon. We have a totally separate address for him from the complaining witness. So there's absolutely no reason for them to have contact with one another. Mr. Spears Parker will continue to avoid contact with the complaining witness. There haven't been any situations that I'm aware of between the two of them since the date of the allegations, which is coming on about a month ago, Your Honor. And now, again, Mr. Spears Parker, we have no contact with that complaining witness, wants to try to keep his job. And he is requesting release on personal bond, but we'd have, due to the nature of the charges, we wouldn't be able to make an objection to the GPS tether, Your Honor.
Thank you. Court heard the representation of both sides, had an opportunity to read the allegations. Court uses clear and convincing evidence standard when it's entertaining a monetary bond. We started out personal bond basis. Court does find that Mr. Spears Parker is a danger, but because he has a lack of a criminal history, okay, and also that there was an injury severe enough to the complainant, fracture to the left eye socket and nose. The complainant had to go to the hospital. While this court thinks that he should have a monetary bond, we're going to try so he doesn't lose his job and the safety of the complainant and the community. We're going to give him a GPS tether work only, and we're going to give him a $75,000 personal bond.
Okay.
Mr. Spears Parker, understand, sir, if you violate any of the bond conditions, next time it's going to be a monetary bond. Do you understand that, sir?
Yes, Judge. Could you further explain to me one more time the bond and?
Sure. $75,000 personal bond. Nobody has to pay any money for you to get out of jail. Bond conditions: no contact with the complainant, Laura Clavin. You're not to possess any firearms or other dangerous weapons. You're not to go back to the Mount Elliott address. GPS tether work only. That means you have to wait at the Wayne County Jail until they put a tether on you. That's like that ankle bracelet. And under the GPS tether, you can only go to your work. Do you understand that?
Yes, Judge. Would I get the tether today?
No, sir. I don't, it may be, I don't know what the time frame is for you to get the tether, but this court is, if you're going to get a personal bond, you need to have a tether.
Okay,
Do you understand that, sir?
So just from my understanding, I will get out today, but I just have to get a tether?
No, you will not get out today. You will have to get a tether before you are released.
Okay.
Okay? Anything else, folks?
I would have to pay the.
Nothing further.
75.
Thank you.
I have to pay the
You don't have to pay.
75,000.
You don't have to pay any money for the bond.
I just have to wait for, I'm just trying to.
For the tether. Yes, sir.
I'm just trying to figure out the timeline of this, 'cause I do, like I said, I do have a job, and I'm just trying to figure out how many days I need to call off.
I don't know how long, but my understanding is it's gonna take some days, sir. I don't know how busy they are. Understand that, Mr. Spears Parker?
Yes, Judge, thank you.
Thank you. Thank you, sir. You can step aside. What's your name, sir?
Omar Brown.
Say that again?
Omar Brown.
Okay, Mr. Brown, sir, this is Magistrate at Chuck Vassar. You're here, criminal matter, case number 0806086501. Sir, you have an attorney?
For the record, Your Honor, Janice Stevenson appearing on behalf of Omar Brown. Your Honor, he stands mute, waives the reading of the information as to the plea of not guilty. Enter on his behalf. Mr. Brown has been advised of his rights, Your Honor.
I'm gonna enter a plea of not guilty. Court date is November 26, 2024, pretrial in front of Judge Bryant. Stand by. Did I miss something? Go, man. Okay. That's her. Okay. Mr. Brown,
Yes.
bond condition, you're not to possess any illegal controlled substances as well as any marijuana while this case is pending. You understand that?
Yes.
Okay. And I will also say that as of March 12, 2020, a warrant was issued for Mr. Brown. He failed to appear and bond was set at $5,000 cash surety. This is from, 2020. Council Vincent, go ahead, please.
Yeah, and in this particular matter, we're not going to have any issue with you converting this to a personal. I have an offense date of May 30th of 2008. We're talking about pot. He supposedly needed to get arraigned 12 years later. Actually wasn't even arraigned on this case. The failure to appear is based on that arraignment that was scheduled that he didn't appear for. So respectfully, it's in front of Judge Bryant, and I think you have authority. So we're not going to be objecting to you changing that over to a personal.
Thank you. With that being said, we're going to do $5,000 personal bond. The court does have authority from Judge Bryant to modify capious bonds, misdemeanor capious bonds. Council Stevenson, any objection?
None at all. Thank you, Your Honor.
Thank you. Thank you, sir. You can step aside. Let's finish up the two males and then we'll do Mr. Grady. Gentleman at DDC, what's your name, sir?
Robert Gould, February 1397.
I'm sorry, what's your last name?
Gould.
Gold?
Yes, ma'am.
Sorry, is your middle name Charles?
Yes, ma'am.
Okay, Mr. Gold, this is Magistrate Chuck Vassar. Not only do you have a criminal matter, but you also have some misdemeanor matters where you did not show up for court. So we're going to recall the warrants, and you're going to get personal bond. Nobody has to pay money for you to get out of jail. Maximum penalty is up to 93 days jail and or $500 fine. Court is going to enter a plea of not guilty. First ticket is P1344665. Count 1 is no insurance misdemeanor. Count 2 is driving under a untitled vehicle. Last ticket is P1391338. Failed to display valid operator's license not on person, no insurance misdemeanor. Court date is December 19, 2024, pre-trial in front of Judge Perkins. Mr. Gold, you have a right to remain silent. Anything you say, orally or writing, it can be used against a court of law. Right to an attorney have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights? Okay, let's go criminal matter, case number 230-577-2601. You have an attorney. Go ahead. First of all, Mr. Gold, please say your full name.
I'm Charles Gould.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Robert Gould, who stands mute, waives the reading of the information after the plea of not guilty and on his behalf. Mr. Gould has been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court date is November 25th, 2024. It's a review court date in front of Judge Robbins. Mr. Gould, while this case is pending, you're not possessing any firearms or any other dangerous weapons. Do you understand that, sir?
Yes, ma'am.
What's your question?
Mr. Gould, before you ask your question, did you have a question about the date? If you have a question about something other than the date, I'm gonna remind you that there is a prosecutor on the screen with you. And your case has already been adjudicated. Anything you say can be used against you. So if you have a question about something other than the date, maybe you want to hold on to that question until you're not on the screen with a prosecutor.
Alright. Very.
Okay. So, September 13, 2024, warrant for Mr. Gould, $910 cash. And this court does not have the authority to modify Judge Robbins' capious bond. Counsel Coyle?
I guess leave it to Ms. Stevenson if she's, because this is a misdemeanor. He adjudicated it down to a misdemeanor, so.
Yeah, we have a motion up before Judge Robbins, but we don't have a response yet. We're still waiting for one.
All right, so bond is gonna be set at $910 cash. Okay, Mr. Gould, let me say this. That if your bond amount changes, your attorney will bring up that matter with the court, and then she'll probably waive your presence, and then the jail will get your new documentation if the bond changes. Do you understand that? Okay, so right now it's $910, and with that, that in reference, so we're going to keep it just until the end of the session, and if not, then that information can be brought up in the afternoon docket. But right now with Mr. Gould, Monday, he has a bond redetermination which is November 18, 2024, 36th District Court, 9 o'clock in front of Judge McConnell or Judge Williams, who will look at the bond amount and bond conditions. Thank you, Mr. Gould. You can step aside. Also, for Mr. Robinson, if nothing's been heard, he also has case number 2305764-801. He will also have a bond redetermination for this Monday, November 18, 2024, 9 o'clock in front of Judge McConnell or Judge Williams, if the bond hasn't changed.
Okay.
Mr. Robbins. All right, DDC, you have a Darren Jones. DDC, do you have a Darren Jones?
No, Your Honor, we do not.
All right. I'll see you in a few minutes. I need to do a juvenile.
Would the people have their witnesses available on the 26th? In person, November 26, 2024 at. It's the last one.
I have to even it out. It's not even out.
What is it?
10 to 8.
Huh?
10 to 8.
9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you, sir. Thank you.
All right, Mr. Gordon, you're all set? There's your notice of your- Don't make a statement.
Greenfield, all the reports. Colleen Johnson just signed it. He needed to have the Zoom information sent to him a second time.
Why did he just sign in? it can't work this way. He will not get another Zoom.
Yes, sir.
And because I'm not working that way. You gotta be here. Court does call the case, People versus Jacob Halfaker. I think I had a bunch of that, the forms that were in there, and one of them is his. Jacob Halfaker.
Assistant Public Defender Hannah Apple appearing on behalf of the defendant. Who I do not.
There wasn't a lot of confidence.
No, Judge, I did reach out. Our office reached out yesterday. I was hopeful that he would be present today. I would ask for an adjournment.
I'm sure you would.
Thank you.
Bench warrant will issue for defendant's failure to appear. Bond $10,000, cash surety. That warrant will issue immediately. Court called case People versus Patrick Hoey. Hoy.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Hoey. Please state your name for the record.
Patrick Michael Hoy.
Hoy.
Your Honor, we are asking for an adjournment. There is some discussion of potential global resolution as well as an OWI case that has been sworn to. It's a new case with a
Right.
offense date of April, so we're waiting.
For that to come, how much? It's been sworn to, has not been scheduled, or what's the?
It's confusing. So it was sworn to on November 11th.
Okay.
But I haven't seen it in JIS yet, and I don't know if it's because they requested a summons on it, but it just showed it. I don't know.
Who, what jurisdiction was it?
The sheriff's office that scored to it, but that's not. Oh, sorry.
Well, where did it occur?
I believe it's 14A3.
You think it's another 3?
Yes,
Okay,
based on what,
Webster.
Webster, yeah, that's, okay. So let's do it this way. Probable cause December 12th. Give you enough time to get that one, figure out what you're gonna do with everything.
thank you, Your Honor.
Bond continue.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Brian Howell. Bless you.
Thank you.
Assistant Public Defender Chinabik Akinwumi on behalf of Mr. Brian Howell. Mr. Howell, state your name for the record, please.
Brian Howell.
All right. You just put 414B recovery.
Yes, Your Honor. Well, we are, we're still in negotiations, but I'd like to put out some fillers for recovery court options for my client.
Probable cause conference, December 5th, 2024, 9 a.m. or as your invite indicates. All right. Thank you.
Your Honor.
Thank you, John.
Case People versus Caitlin Krogstad. Is he only in custody? They've been held up waiting on Mr. Johnson. Okay, we'll get him back out here so we can get to jail because he's held up everything today.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Ms. Krogstad, who's here to my right. State your name, ma'am.
Caitlin Krogstad.
Thank you.
Your Honor, we would, first, the people have made an offer to, upon a plea to the domestic violence count, to dismiss the felonies and with 4A, I have gone over that with Ms. Krogstad. She wishes to reject that offer, and we wish to set this matter for exam.
For exam.
Yes.
So you have all the discovery.
Yes, I believe so.
Would the people have their witnesses available the 26th? Preliminary examination in person, November 26, 2024, 9 AM before 12 PM before me. We'll continue.
Thank you, Your Honor.
Court calls the case, people recalls the case, People versus Demetrius Caldwell.
Absolutely, people.
Kareem Johnson, appearing on behalf of Mr. Caldwell.
Mr. Johnson, you needed to be here when we had this case before. I permitted Zoom. The thing is there will be no more Zoom. You'll have to be here, particularly when your clients are in custody. What are we doing on your name, sir?
Demetrius Caldwell.
What are we doing on this case?
Set it for exam, Your Honor.
I have concerns about setting this for an exam. I'm just pending competency, I believe, in 15th District Court in case 22-35 SM. That's my understanding from what I'm reading in my notes.
Is there competency on another matter, counsel?
When I addressed that last week, the prosecutor didn't know. I spoke with my client yesterday at the jail. We talked about the case, the nature of the preliminary examination. I had no competency concerns.
But if there's a competency pending, we've got a problem. Sir, you have another case at 15th District Court? Right, do you?
Right.
Who's your attorney on that? Is it the
No.
public defender's office?
Ipsy?
No, it's in Ann Arbor, right? Do you have another attorney that's representing you?
I think so, yeah.
And Your Honor, the most recent note in that file is from October the 23rd. It indicates that before Judge Perry, the defendant did fail to appear, but his guardian appeared. Public defender Cannon was there for the defendant. It said that case had been adjourned for the defendant to complete his competency evaluation. It was adjourned out to December the 18th. He was supposed to complete his competency evaluation. That's all the information I have, but I didn't want to set this if there's still that evaluation pending in a different matter.
Your Honor, Mike Getty from First Assistant Public Defender. We did look it up. There is a.
Attorney, go ahead, counsel.
Janice Stevenson, appearing on behalf of Angela Hemingway, who stands mute, waives the reading of the information after the plea of not guilty, as Hemingway has been advised of her rights, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are November 25th, 2024. Probable cause conference followed by preliminary examination, December 2nd, 2024. Both matters are in front of Judge Giles. Okay, Counsel Coyle, you're here on behalf of the people.
I am, Your Honor. Lisa Coyle, appearing on behalf of the people. Your Honor, I see an old felony record from her from over 30 years ago. This is non-assaultive. No objection to a $20,000 personal bond in this matter.
Thank you, Ms. Hemingway. Your attorney is going to be asking for a personal bond. Also, sir, you're going to get a $20,000 personal bond. You understand that? That means nobody has to pay any money for you to get out of jail.
Okay.
Understand that, Ms. Hemingway?
Yes.
Okay. Good luck, ma'am. Go to court when you have to. Take care of your matter.
Thank you. Thank you.
Come on, Tish. Say your full name.
Lakeisha Bivens. Is Lakeisha Renee Bivens, ma'am? Yes, ma'am. Thank you. This magistrate at there, case number 140-619-7701. You have an attorney. Go ahead, counsel.
Janice Stevenson, appearing on behalf of Lakeisha Bivens, who stands mute, waives the reading of the information after the plea of not guilty be entered on her behalf. Your Honor, Ms. Bivens has been advised of her right.
Thank you. I'm going to enter plea of not guilty. Court date is November 26, 2024. Pre-trial in front of Judge Garrett, Austin Garrett. All right, Ms. Bivens, bond conditions, you're not to have contact with Samuel Palmore. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. You understand that, ma'am?
Yes, ma'am.
Okay. I will also indicate in August 28, 2023, a warrant was issued for Ms. Bivens. Bond was set at $100, 10%. Also, Vincent, it's a 2014 case, I believe. Go ahead, Esteban, please.
Yeah, I see that as well, Magistrate, and I'm sorry for the people, P71917. The problem that the people are running into here regarding this defendant is we look at the incident date, it was 2014. This is strictly a flight issue though. So she was arraigned in November of 2019, and then at her first hearing, she failed to appear. And then she ends up getting arrested on a bench warrant 4 years later. On that bench warrant, there was $1,000 cash surety. The arraignment, actually, that cash surety bond was continued, only to have it go in front of Judge McConico, who lowered it to $1,000 personal. And then at the next hearing, she failed to appear again. And now, while she was on a bench warrant for this failure to appear, Magistrate, I know you have a lot going on, but she was just in our courtroom yesterday. You ended up arraigning her. She only got picked up for this warrant because she got arrested for that arson case that was before you yesterday. Where she was
$50,000, case number 24060485001. She got a $50,000 personal bond with a number of bond conditions.
Right. And I think the reason why it was higher, it wasn't my case, in addition to, the allegations as well as the charges, was her prior history, because she has a highly assaultive prior history. So I guess the argument here is she would have never shown up for this case, clearly, because she evaded this as soon as she ended up getting a personal bond, not showing up. As soon as Judge McConico converted a cash bond to a personal bond, she didn't show up. And then the only reason why she's before us today is because she was arrested on that arson case. Assaultive past, flight history, it's $100, 10%. Quite honestly, I don't care about the $10. I think a tether is more appropriate to ensure that she comes to court. And that's where I'll leave it, Magistrate.
Thank you. Counsel
Your Honor,
Stevenson,
Ms.
go ahead,
Bivens.
please.
Thank you. Your Honor, Ms. Bivens is 40 years old. Her only source of income is disability at this time. She is a cancer patient, not getting the medical treatment that she needs during her time over there at the Detroit Detention Center. This is a misdemeanor from 2014, Your Honor. Not certain where it's going with regard to cooperation complaining witness, who I think was trying to evict Ms. Bivens 10 years ago at this point. So the bond is set on the other cases, a pretty substantial personal bond. Ms. Bivens knows that she's got to be back in court. We hope that she would choose to do that. We ask the court to release her on personal. No contact with the complainant.
The thing is, and when she was arraigned yesterday in front of me by me, is that she's not getting the medical attention that she is supposed to get at the jail. And I believe that was a big factor. And so while I think monetary bond or GPS tether would be appropriate because of her medical conditions, okay, I'm gonna give her $100 personal bond, and I'm not gonna put a tether. However, at some point, Ms. Bivens, okay,
Yes, ma'am.
you're not showing up. Just letting you know, not showing up. And at some point, you have your medical conditions and not getting your medication. That may end up you having a monetary bond if you don't show up. You only get so many chances, Ms. Bivens. So please take care of your matter. It is $100 personal bond.
Magistrate, before we end this, is there any way to meet in the middle? The people won't object to her voluntarily submitting herself for a tether. She can get released today. She can still take care of all of her medical issues, but we have an arson case that's going on right now. in a case clearly that she's avoided. So, I mean, is that something that you would consider if it's only regarding the medical issues? Because we can solve that. Let her go and then
Well-
submit herself for the test.
Okay. We'll
So,
give her that one.
may I respond to that?
No, we will give her another opportunity with a personal bond. If Ms. Bivens does not deal with, because Ms. Bivens more than likely will come in front of me again. And if we don't have a good reason, while she is not attending to a court or she's violating any of the bond conditions, she just may end up with either a monetary bond or she may end up with a GPS tether, even with her medical conditions and not getting any medication. It's not so much as this, it may be on the other matter. But Ms. Bivens was made aware of that, because I recall this now, was made aware of that yesterday. So we're gonna give her one last chance.
Okay, Magistrate, I appreciate you for listening to me.
Thank you. Thank you, folks. That concludes Ms. Bivens' arraignment. Thank you, DDC.
You'll see us
I'll see you. I'll see, not me. You'll see Magistrate Ramsey Heath, and I will see you over the weekend.
Copy that. Have a good one.
Thank you, Magistrate.
Thank you.
Oh, we did? Don't sign up.